Hey there, I'm Jeff, and in addition to being a patent lawyer, I'm a multi-exit entrepreneur. So I have a unique background on what it takes to actually not only patent products, but to develop concepts into products that are worth patenting. So today I wanted to tell you a little bit about what you might do as someone with an idea that you want to protect with a patent before you start talking to a patent lawyer. Over the course of several years and after working with hundreds and hundreds of clients, there are several things that my best clients have done to make my job easier as a patent lawyer and also make me more efficient so that my clients don't have to spend as much money on the services that I provide, but more importantly, make me more effective and get a broader and better scope of coverage for the inventions that they are trying to protect with a patent. So maybe you have a product concept and you think that you're ready to go and build it and patent it, and maybe you don't know where to start. So to prepare yourself to have a more effective and efficient communication with your patent lawyer, these are the things that you should start thinking about before you have that conversation. So one of the first things that I need to know as a patent lawyer is where you are in the product development process. Do you think that you've conceived a finalized version of the product, or are you planning on iterating the product to make it better or more optimized in some way? On one hand, it's important to file your patent application early because we're in a first to file system in the United States, meaning that whoever files their patent application first in the patent office has the priority of right in that invention over someone else who files later. In other words, you're in a race to the patent office, so it's important to file a patent application early. But on the other hand, the type of patent application that you file, whether it's a provisional or a non-provisional patent application, and the approach that you might take in terms of building a single patent application or maybe planning to file multiple patent applications over time by subdividing your meta invention into several sub-inventions. All of those are the kind of considerations that I'm thinking about when you come to me and tell me about where you are in your product development process. Then it's also important for you to think about when and where you plan to sell your product. Maybe the most obvious consideration with regard to this issue is whether or not you plan to commercialize your product only in the United States or whether you plan to sell this product internationally. That impacts the type of patent application that you file, and especially the timing. Another thing to think about is whether or not you need to disclose this invention right away. If you do, then it's probably going to accelerate the time frame under which we need to prepare and file a patent application. Another thing to think about is whether or not you plan to disclose this invention to any third party anytime in the near future. For example, you might think you need to talk to engineers, or maybe you want to pitch the invention or the product to investors. This might impact not only the patent process, but other agreements that you might have in place. For example, non-disclosure agreements and invention assignment agreements that might be required to expand the scope of coverage and protection that you have over your inventive concepts and your products. It might also impact the timing of which you file your patent application, because typically you want to file a patent application before you make those disclosures and get your invention under patent pending. Otherwise, you could risk losing patentability over your product. One item that might not be obvious to inventors and people with product concepts, whether or not you as the inventor or the conceiver of the product have incorporated a business. The structure of your business entity and whether or not you want your invention assigned to your business entity might have an impact on your patent strategy and how we go about preparing and assigning the patent application. Somewhat relatedly, it's also important for me to know who has contributed to the development of your inventive product and to what extent. If you've worked with employees to conceive of different aspects of the product, or maybe you've worked with third-party engineers or other contractors, it's important to understand what kind of agreements, whether they're employment agreements or contracting agreements, that you have in place with all of these parties who have contributed to the invention, so that we can best and most effectively and most properly file the patent applications and allocate those inventive rights. Another thing to think about is whether or not you've done any patent searching related to your invention. In other words, have you thought about any similar concepts that are already publicly available? And to what extent is your inventive concept similar to things that maybe are already on the market or sold by competitors? It's important to come to your meeting with your patent attorney with a list of the concepts that you think are the most similar and how your inventive concept differs from those concepts. If you can, it might be good to think about the problems that those other concepts solve, particularly in cases where your inventive concept or product is a solution for those problems, because that helps us articulate a story of how your invention is different from the closest products or concepts that have already existed. Then, especially when it comes to the specifics of the inventive product itself, it pays to be organized. It is critical to organize the description of your invention as a series of solutions for problems that you are solving. Your invention should represent a series of solutions that solve one or more problems that other products have faced. During our initial meeting, it would help to come organized with a list of problems that your product solves and how the individual components of your product or your invention represent solutions to those problems. Your inventive product in the patent application will be characterized as a combination of sub-solutions, each tied to one big problem or some sub-problem that your invention solves. Then we need to unpack the specifics associated with your invention. What are the materials of your product? What are the dimensions? What are the steps to use the product? What are the steps to manufacture the product? All of these are important and critical things to know, or at least have an idea of, before you come into a meeting with your patent attorney in order to make your patent attorney work more efficiently. It's also helpful to think about the best way that you know of to make or use your invention, but also alternative ways that either you or especially your competitors or hypothetical competitors in the future might conceive of to make or use your invention. Speaking of competitors, in order to help your patent attorney talk about your invention and build a story about your invention in a way that encompasses your competitors' anticipated uses, the way that you think your competitors might try to knock you off, it helps for you to come with a list of who you think your competitors for this inventive product will be. If you know anything about your competitors' plans for their product portfolios, it'd be helpful to bring that information to the meeting as well so that your patent attorney can help you define your invention in a way that encompasses the most expected uses that your competitors might have for your products and technologies. And finally, contextually, it's so helpful to understand what your plan is with your inventive product. Will it be part of your ongoing business, or do you plan to sell the product to someone else, the rights to the product to someone else? And then do you plan to sell the business that offers the product that the patent would cover? And if so, who do you plan to sell it to? Who might be interested in buying this? All of those can be helpful points to maximize the value of your patent protection. When you have all of these items well thought out and well articulated, it helps your patent lawyer be much more efficient in terms of the work that they need to put into the project from the start. And more importantly, it helps your patent attorney do a better job building out the story of your invention in the context of a patent application. If you'd like to consult with me on a product concept, feel free to schedule an appointment with me at the calendar below. Remember though, we're in a first-to-file system, which means that two inventive concepts are similar. The party that files first will have the priority in that invention. In other words, if you have a concept that you want to protect with a patent, you're in a race to the patent office. And you certainly should at least think about filing a patent application before making any disclosures publicly about your inventive concept if you want to preserve your right to be able to patent that concept in the future. I hope that this video has been helpful for you, and I look forward to learning about how I can help you in the future. Let's talk soon.